I am not here to divulge the opinion that we will send to the National Telecommunications Commission in a few days. But I am here appearing as a resource person in the hope that I may somehow contribute on the matter of how to deal with a peculiar situation of a franchise applicant whose franchise is about to expire, and bills have been filed for the renewal of its franchise, but quite unfortunately, Congress may not be able to act on it before the expiration date. So if the honorable senators will permit me to state certain relevant facts, I think that based on the records in our possession, the following facts are undisputed. Number one, in the case of ABS-CBN, its franchise covered by Republic Act number 7966, enacted on 30 March 1995, provides for a term of 25 years from the effectivity of the franchise. Section 15 of the franchise provides that it becomes effective 15 days from date of publication in at least 2 newspapers of general circulation. Based on facts available to us, the franchise was published on April 19, 1995. For that reason, the franchise will expire on May 4, 2020. Another fact, various bills have been filed in Congress for the renewal of ABS-CBN's franchise. Next, there are indications that Congress will not be able to act on the said pending bills before the expiration of the franchise on May 4, 2020. There is nothing in Republic Act number 7966, that's the franchise of ABS-CBN, in the radio control law, in the public service law, or in any other law that provides for a situation where a franchise expires during the pendency of its application for renewal with the Congress. And therefore, the issue before us is whether or not ABS-CBN or any entity similarly situated may continue to operate after the expiration of its franchise and during the pendency of various bills for its renewal in the Congress. What is the DOJ position on this matter? Number one, there is a gap in the law that could have declared the status of operations of a radio and television franchisee when the Congress has not finally acted on a bill for the renewal of its franchise. Number two, when there is a gap in the law, equity comes in to fill the gap. Equity is the principle by which substantial justice may be attained in cases where the prescribed or customary forms of ordinary law are inadequate. And that is a citation from Enrile versus Sandigan Bayan, citing Reyes versus Lim, a 2003 case. Considerations of equity have apparently been applied in previous similar situations presented earlier, namely, among others, PTNT, Smart Communications Incorporated, Catholic Bishops' Conference of the Philippines Incorporated, all of whom were allowed to operate despite expired franchises as long as the application for the renewal of these franchises were lodged with the Congress before the lapse of their term. Number four, the grant of a franchise is an exercise of sovereign power, and under our Constitution, that power is vested in the Congress. By necessary implication, such power of Congress also includes the power to prescribe the rights of a franchisee applicant pending final determination of the renewal of its franchise by the Congress. It is therefore respectfully submitted that the Congress, by a concurrent resolution, may authorize the National Telecommunications Commission to issue a provisional authority subject to such terms and conditions as the NTC may deem fit to ABS-CBN and other entities who are similarly situated, authorizing them to continue operating, subject to the Congress's eventual disposition of their renewal applications.